Good afternoon, everyone. Welcome to today's webinar organized by the Finance and Tax Academy on the newly launched Revenue Tribunal introduced in January 2026. This tribunal is an important development in our tax system. It has been created to provide a dedicated platform to handle tax dispute in a more structured and efficient way. For taxpayers, advisors, businesses, and finance professionals alike, understanding how this new body works is essential. In simple terms, the Revenue Tribunal offers a clearer process for challenging tax decisions. It aims to improve transparency, ensure technical expertise at hearings, and strengthen trust in the dispute resolution system. Today, we will look at what this means in practice, how appeals will be handled, what procedures to expect, and why these matters for you and your clients. We are very pleased to have this session moderated by Tanuja Pajala, a seasoned tax trainer of the Academy. Tanuja will guide us through the key aspects of the new tribunal and highlight the practical points that you should be aware of. This session is designed to be interactive. Feel free to send your questions. Thank you for joining us today. And without further ado, I invite Tanuja to commence the session. Good afternoon. A warm welcome.
We are honored to have with us today a distinguished panel of experts who will guide us through both the legal and practical dimensions of the tax dispute resolution reform. It is my immense privilege to introduce our first panelist, Met Mohamed Irshad Kassam Loulou. Met Loulou is the president of the Financial Intelligence Unit and is a practicing barrister at the Mauritian Bar. He devoted more than 2 decades at the ARC, serving as vice chairperson from 2003 to 2006 and as chairperson from 2006 to 2024. For 18 years, he led the committee at the highest level, presiding over complex and precedent-setting tax disputes and overseeing the development of Mauritius tax appeal framework. Prior to his role at the ARC, he served as district magistrate, senior district magistrate, and presiding magistrate of the District Court of Port Louis. His career reflects deep institutional knowledge of Mauritius tax adjudication landscape, making him uniquely positioned to provide insight into the evolution from the ARC to the Revenue Tribunal. Our second panelist is Met Gulshan Sharma Jorai. Met Jorai currently serves as acting chairperson of the Revenue Tribunal, where he plays a central role in the adjudication of tax disputes within Mauritius' evolving revenue law framework. He brings a strong academic and judicial foundation to this position. He holds an LLB honors from the University of Mauritius and an LLM from the University of Toronto, which specialize training in international taxation. Prior to his current role, Met Jorai served as district magistrate from 2009 to 2016, gaining substantial judicial experience before transitioning into the tax appeal system. He subsequently served as vice chairperson of the ARC, where he was directly involved in complex tax matters and in the institutional development of the dispute resolution framework. We also have Mr. Ryan Alas with us. Mr. Ryan Alas serves as Managing Director and International Tax Lead at Rogers Capital Tax and is the President of the Tax Africa Network. He is also the Chairperson for the Tax Committee at Mauritius Finance. He is a fellow of the Association of Chartered Certified Accountants and a member of the IFA. He brings over a decade of experience in international taxation, cross-border structuring, and transfer pricing. His career spans senior roles across both advisory and regulatory environments like EY Gabon, Katanga Mining, PwC Mauritius, and FSC of Mauritius. Ryan holds a BSc Honours in Accounting and Finance, along with a postgraduate qualification in International Tax Planning and Treaty Interpretation from the Royal Society of Fellows, USA. With extensive experience across African markets, he advises multinational groups and investors navigating complex tax and regulatory landscapes on the continent. And finally, but not the least, we have the charming Maître Angie Fogou-Boulel, who is a senior state counsel at the Attorney General's Office of Mauritius, where she specializes in tax litigation and advisory within the public law framework. In her role, she regularly appears before the Supreme Court and specialized tribunals, representing the state in complex tax and public law matters. She also advises key government institutions, including the MRA, on high-level revenue, regulatory, and constitutional issues. Her work places her at the intersection of tax enforcement, statutory interpretation, and administrative law. Maître Angie Fogou-Boulel holds an LLM in international tax law from King's College, further strengthening her expertise in cross-border taxation and global tax developments. She has also represented Mauritius at international forums, including COP28, reflecting her engagement in matters with both domestic and international implications. Her experience provides a valuable public sector and litigation perspective on the evolving tax dispute resolution framework in Mauritius. Together, our panel brings a balanced and comprehensive mix of institutional, legal, and practitioner perspective, making today's conversation both timely and richly informative. Thank you all for making time to make it for this webinar and participating. Thank you.
Thank you for having us.
So, to frame today's conversation, let's take a moment to look at how the tax appeal mechanism has evolved over the years. Mauritius originally operated under an income tax regime where disputes against tax assessments could only be appealed directly to the Supreme Court, making the process formal, costly, and time-consuming. In 1984, the Tax Appeal Tribunal was set up under the Tax Appeal Tribunal Act. At the time, the tribunal served as the primary independent body for taxpayers challenging assessments raised by the tax authorities. The Tax Appeal Tribunal was operating similar to a court of law. It appeared that the tribunal's procedures were excessively cumbersome, marked by legal complexity and an overly formalistic framework that proved challenging for taxpayers. A major shift came with the creation of the Assessment Review Committee, ARC, under the Unified Revenue Act. In 2004, the ARC then came under the purview of the Mauritius Revenue Act of 2004. Now we are witnessing the next significant chapter with the establishment of the Revenue Tribunal, brought into effect under the Revenue Tribunal Act 2025. Its mission is to resolve revenue disputes fairly, effectively, and expeditiously in accordance with legal principles and best practices. Maître Lolu, having served as the chairperson of the ARC for over 20 years, you have had a unique vantage position to experience and see the transition from the Tax Appeal Tribunal to the ARC and now the Revenue Tribunal. I'm sure you have lots to share with us and the audience on how the evolution went and probably inside stories as well.
Yes, well, good afternoon, everybody. And thank you for the very nice introduction. And thank you for giving me the opportunity to share with you my experience at the ARC. To put in perspective the the creation of the Revenue Tribunal, I think it is interesting to know the history of how the ARC was set up and how it evolved into this Revenue Tribunal over a period of 23 years. Like you have said, the ARC was set up in 2003, around March, if I'm not mistaken, under the Unified Revenue Board Act. At that time, the chairperson was a former head of customs, and I was appointed the vice chairperson. Now, the reason why I was appointed vice chairperson was that it was essential to have a lawyer there, because obviously there were going to be issues of law to be dealt with before the ARC. One interesting fact at that time was that the ARC started to function in parallel with the Tax Appeal Tribunal. When the ARC came into existence, the Tax Appeal Tribunal was given 1 year to complete cases already started before the tribunal. And at the close of the tribunal, all cases pending were to be transferred to the ARC. The reason why the Tax Appeal Tribunal was replaced by the ARC was that at that time it was considered that a quasi-judicial body which would be less formal in dealing with cases was desirable. Another interesting fact about the beginning of the ARC was that at that time the chairperson and vice chairperson were appointed on a contract basis by the Minister of Finance. And so were the members of on the panels of the ARC. The reason why I think this is worth pointing out is that the employment on contract of the chairperson and vice chairpersons has remained a constant feature of the ARC for over 20 years. When, in my view, a person adjudicating in a quasi-judicial capacity cannot have the required independence to do his work as it should. At least, he is not perceived to have the required independence because he does not have security of tenure. I am sincerely hoping that now that we have a revenue tribunal, the government will do away with this employment on contract of the chairperson and vice chairperson. This is not healthy. The reason why in 2003 the ARC had a chairperson and vice chairperson on contract was that there was a reason for that. It was that the ARC was not meant to last for more than 3 to 5 years. At that time, the government was going to set up a tribunal again soon after the close of the Tax Appeal Tribunal. Now, why the government wanted to close the tribunal to open another one soon after, your guess is as good as mine. But I must say it took almost 23 years to set up this other tribunal. Now, the appointment of the chairperson and vice chairperson by the Minister of Finance, as it was then, was very soon challenged as being improper. And for those who have known him, it was Mr. Guy Olivry, QC, who first took that point. He expressed his intention to take up the matter before the Supreme Court on occasion arising. However, there were already decisions of the court, for instance, in the case of the MCCB tribunal, where it was decided that an administrative tribunal was not unconstitutional as long as there was an appeal to the Supreme Court. Globally, this is the decision. So it was not clear whether there was an issue of constitutionality there, although I think it is true that the perception of independence was shaky with this type of appointment. In 2004, like you've said, the MRA Act came into force, and the ARC was then placed under the MRA Act 2004. there was no significant change from what obtained under the URB Act as far as the jurisdiction and functioning of the ARC were concerned. Nevertheless, in 2006, the posts of chairperson and vice chairpersons were advertised by the PSC. So it was no longer the minister who was appointing. And I had to apply again, went for interview, and I was appointed chairperson of the ARC, but again on a 5-year contract. I'm not sure the PSC holds many interviews to appoint people on contract for a period of 3 to 5 years in the public service. But at that time, I think it was not a common occurrence. So the ARC, as we have known it, as Mr. Alas has known it, came into existence with 1 chairperson and 2 vice chairpersons at the beginning. I must say it was not easy to find a second vice chairperson because many lawyers were not very keen about a 5-year contract. I am glad to see that after almost 21 years, there are 2 things about which we have been fighting to obtain, Mr. Jorai and I. After 21 years, there are 2 things which are now in place, among other things, of course. The first qualm that we had was that the ARC was called a committee, Assessment Review Committee. And as a committee, it was not perceived as an institution as serious as a tribunal. People coming before the committee very often had an attitude of désinvolture. This is just a committee. I'm very sorry to say I've even had state law officers who say this is just a committee. So for a proper decorum, we submitted to the Ministry of Finance many times that the appellation had to be changed into something else. But unfortunately, it was never done. And it was, in fact, never even discussed at a high level. The second thing that we fought about was the employment on contract of the chairperson and the vice chairpersons, as this did not convey an impression that the chairperson and vice chairpersons had the required independence to function as they were supposed to. Of course, in practice, we did defend our independence, a bit like Denmark defended his sovereignty over Greenland, right? But it was not just a question of independence of the chairperson and vice chairpersons. There was more inconvenience caused by this situation. For instance, every time we tried to negotiate our salary with the PRB, we were told, well, you work on contract, you should negotiate with the Ministry of Finance. So when we go to the Ministry of Finance, and Mr. Jorai will confirm, we've often had that, when we go to the Ministry of Finance, we are told, well, sorry, you're governed by the PRB. So it was never established, actually, whether we were considered as being in the service or not. Sometimes we were, sometimes we were not. And one big inconvenience is that, when you're still young and you're working, try get a housing loan over a period of 20 years when you have a 5-year contract. It's almost impossible. The third thing was that, with which we were not agreeable, was that the ARC was set up under the MRA Act. And it fell under the Ministry of Finance, just like the MRA. It must seem unimportant, but in fact, the perception was that the ARC, being under the MRA Act, was part of the MRA. I have personally heard it many times that, the ARC and the MRA, they're just one body. This wrong perception was harmful to the ARC, as taxpayers could be under the impression that the ARC was not independent, which of course was not true, but it could give that impression. To make things worse, The ARC, unlike the Tax Appeal Tribunal, was placed under the Ministry of Finance, the same ministry under which the MRA fell. I must point out that the Tax Appeal Tribunal was under the Attorney General's office. So having both institutions, the ARC and the MRA, under the Ministry of Finance, could only make the wrong perception worse. Now, obviously, there's no need to mention that the Ministry of Finance, their main concern is, preparing the budget, so getting money in the treasury of the government. The ARC could not be perceived as a tax collector for the state, which it was not, actually. To be fair, I must say that in 2013 to 2014, just before general elections, there was a Revenue and Valuation Appeal Tribunal bill that was presented to the National Assembly in first, and if I'm not mistaken, in second reading as well. There was, at the time, a problem in that law, in that bill, regarding the constitutionality of having the Valuation Tribunal together with the Revenue Valuation Appeal Tribunal. A Valuation Tribunal is a tribunal that is set up ad hoc to consider cases of compulsory acquisitions of people's properties by the state. It is normally chaired by a magistrate or a judge. Without going into the intricacies of how and why it was a problem to put the Valuation Tribunal together with the Revenue Tribunal, let's say that some honorable members in Parliament drew attention to this problem, and either the law was going to be amended or the Constitution. Personally, I don't think it's a good idea to amend the Constitution so that a particular logo doesn't get caught in the net of unconstitutionality. I think it should be the other way around. Laws should be in conformity with the Constitution. But anyway, there was discussion, but soon after, unfortunately for us, Parliament was dissolved. There were general elections. There was a change in government, and we did not hear about that law again. But there was this attempt at that point. Now, I must say I'm very happy to see that finally the point, what we've been fighting for the past 23 years is now in place. A proper revenue tribunal under a proper Revenue Tribunal Act. Not MRA Act, not URB, not anything, a proper Revenue Tribunal Act, which has been proclaimed and which is setting up a proper tribunal. I can only hope, sincerely hope now, that the chairperson and the vice chairpersons will not again be employed on contract of 3 to 5 years. I also hope that the tribunal will not be under the Ministry of Finance. The tribunal should be able to function with the decorum and independence that it has, and the perception that people who come to the tribunal have must align with these. One last thing, if I may. I was not happy about something which has now been set right by the Revenue Tribunal Act, and it concerns appeal to the Supreme Court. Under the MRA Act, from the ARC, an aggrieved person, somebody who did not agree with the decision of the ARC, could only appeal to the Supreme Court by way of case stated. This means that the aggrieved party could only appeal on questions of law. This implies that, firstly, there had to be a point of law to appeal. If there was no point of law, he could not. And regarding appreciation of facts, if the party did not agree with the appreciation of facts by the committee, it was a bit more complicated. The matter was, the finding had to be so perverse that no reasonable person would have reached such a decision. Then only you could appeal to the Supreme Court. There was a case of Supramania versus the Director General, in which the appellant put the word perverse in all his grounds of appeal. the decision of the committee is perverse for this reason, perverse for that reason. Like the committee was like a state of Epstein, I don't know. Anyway, his counsel and the appellate were told off by the court. And the court said, it's not because you use the word perverse in all your grounds of appeal that it is a proper appeal by way of case stated. The Supreme Court considered also that the appellant had made an abuse of the word perverse in his grounds of appeal. I must say, there was a time when there was an attempt to have a full-fledged appeal to the Supreme Court. There was this attempt. But the reason why it never went through, this full appeal, was that it was considered that tax law cases were too technical, and two judges sitting at the Supreme Court might not have had the required technical knowledge to deal with such cases. You know, the Tax Appeal Tribunal and the ARC, we have panels consisting of not only a lawyer, but people who are well-versed in tax matters, accountants and all this. The judges of the Supreme Court do not have this possibility. So it was considered that technical matters were best left at that time to the Tax Appeal Tribunal, afterwards to the ARC. In any case, it was nothing peculiar about Mauritius, because appeal by way of case stated exists in other jurisdictions regarding administrative tribunal.
So, Matlulu, I think this was an impressive display, and you painted the picture so well on the history and the evolution of the dispute resolution. I don't think anyone would have this from a simple Google search. We are very grateful for that expose.
I thank you.
And I will now turn to Medjugorje. I think you have been working years alongside Irshad, and you probably, as he mentioned, had the same challenges. You've seen the evolution from the ARC to the Revenue Tribunal. Now you're spearheading the new tribunal. What are your feelings about this transition, and what are the challenges now you're facing as the acting chairperson?
Well, it occurred in this order itself. So it was first Mr. Lulu in the order that we are intervening today. And I was appointed as acting chairperson of the ARC in July 2024. 1 month later, the Revenue Appeal Tribunal bill, the RAT bill of 2024, was introduced abruptly and without consultation with us. Nevertheless, I considered it necessary to articulate the ARC's position, since we were obviously directly concerned. The first thing I proposed, which I can now share, is to reconsider the name, since it's obviously not glorifying to be the chairperson or vice chairperson of RAT. So the Revenue Tribunal bill, which came in 2025, sous la houlette of a new Attorney General, took on board most of ARC's 2024 proposals. Nevertheless, certain matters remain outstanding, and I'm glad that following constructive engagement, further refinement were brought at committee stage to address most of our concerns. Viewed in its broader institutional context, the transition from the ARC to the Revenue Tribunal constitutes a decisive moment in the evolution of revenue dispute resolution in Mauritius. It has been widely characterized, correctly in my view, as a landmark milestone in the institutional landscape. The establishment of the tribunal is intended to rationalize and modernize the adjudicative process, embedding clearer safeguards, reinforcing procedural coherence, and enhancing both accessibility and public confidence. However, the proof of the pudding is in the eating. The true measure of this reform lies in its implementation. Legislative architecture, however well conceived, must be animated by the collective commitment of all stakeholders. Only then will the transition achieve its intended objective.
So, you feel that there is the support of all stakeholders while this transition is being made?
Indeed. Well, this webinar, for example, is an illustration that all stakeholders are participating in this transition. In fact, in terms of the rationale of having the Revenue Tribunal itself, I believe that two features deserve particular emphasis. First, as Irshad has mentioned before me, the creation of a tribunal under its own autonomous legislation marks a structural realignment. The ARC set up under the MRA Act gave the mistaken impression, as emphasized earlier, that the ARC was a subsidiary of the MRA. In other words, this reform addresses the perception of overlap between the appellate body, which is the tribunal, and the body whose decision it reviews, which is the MRA. Institutional clarity in this respect is fundamental to the credibility of any appellate mechanism. Secondly, the Revenue Tribunal Act places deliberate emphasis on procedural efficiency and accessibility. Contemporary adjudicative systems recognize increasingly that justice delayed undermines legal certainty, particularly in fiscal matters, where commercial planning and compliance depend upon timely resolution. So in this regard, I think this reform is timely and was essential.
Wonderful insight in your views on this transition, and happy to see that the recommendation and the fights that you have both been leading is resulting in positive outcome, and you're seeing light out of the tunnel.
Indeed, it took long, but luckily
it did. As I mentioned, 23 years plus. Now I will turn to Ryan. Ryan, you have been a tax expert. You have been accompanying your clients, taxpayers. How do you, as tax practitioner, view this evolution, and has it been welcome? Is there any challenge that you are facing at the moment with that transition?
Now, I think, thank you, first of all, thank you, Tanusha. Great, I learned a lot of things from Met Lulu and Met Joy. But what I can say is, from a practitioner's perspective, there has been a shift, procedural shift, but not drastic. And it's not a bad thing, because we must not just suddenly find things completely different procedures to be followed. And I think one of the important things that Major I just mentioned, that just sometimes justice delayed is justice denied.
Yes.
One of the issues we had previously is that there were a lot of delays. And the delays is not because of the committee, but sometimes because it took a lot of time for a hearing. Most of the procedures before was oral. There were, of course, before we could file statement of case, we could have witness statement, but it was not, as far as I understand, a compulsory requirement. So, and most of the evidence was produced through examination in chief principally and cross-examination of the witness, which took a lot of time. And we need to know when each lawyers will have common dates, etc. It took a simple case can need 4 or 5 hearings. Now with the fact that we have a witness statement which will be filed, as per the procedure of the rules of the tribunal, the witness will only be called for questions by the tribunal. So I think on this we'll get a lot of time.
Yeah.
This will speed up matters. Second thing is that we have the statement of case, which in some cases the burden will be on the taxpayer, and in other cases it will be on the MRA. And this statement of cases sometimes can already contain all the information that can help the committee, the tribunal, to decide a case. So, and there is a provision, I think, I don't know if it's in the rule or the act, that the tribunal can give a decision based on the statement of case itself. Of course, in many cases before, taxpayers, they relied on the MRA statement of case. So it was the MRA who would produce all the evidence, all the documents that was provided. And but now this burden has shifted in some cases to the taxpayer. Yeah, to the taxpayer. And the taxpayer must ensure that they have everything ready, the statement of case is complete. And maybe other things that I can add as well in terms of procedures. So as the committee, the tribunal is also flexible that, sometimes, particularly in small cases, it's not easy for taxpayers to appoint counsel, etc. They can also be assisted by professional accountants. And I know at the time there was a law, I think, which stated that only people who were registered who would be able to represent a client at the tribunal, apart from lawyers. But this was not implemented. I think it was never implemented. I think this is something that maybe should be considered as well, because accountants it's very vast. There are some accountants who are tax specialists, but there are many accountants who have no knowledge of a specific knowledge of tax, and to appear to represent a client before the tribunal, it's just the same thing as preparing financial statement or doing double entry, etc. So I think automatically all professional accountants to be able to represent clients, maybe this is something that can be reconsidered, so that it is all taxpayers, when they are represented by someone, they get they're properly represented.
Yes, because it's not only on the facts of the case, it's also a lot on the procedures aspect as well to get it right.
Exactly.
At the very instance.
Yeah, exactly. It's not only based on, of course, in many cases it's based on facts. You will need to have a knowledge of accounting. When lawyers represent clients, they will be assisted by an accountant. But when an accountant represents a client, he also needs to know the procedures of the tribunal. Yeah. At least, even if he's not a lawyer, at least have some basic knowledge of the law as well.
Exactly. Yeah. Thank you for that take on the changes, and probably a bit of the comparison on how the ARC and the Revenue Tribunal is operating. I'll now move to Angie. And Angie, you have been you have been counsel at the AGO, representing in front of the ARC and now the Revenue Tribunal. How are you feeling the transition? Is it the same? Have you noticed certain changes in the way you approach the cases?
Thank you, Tanuja. Firstly, I have to say I feel like a mere mortal amongst titans here. So I'm incredibly privileged to be sharing this panel with all of you. And we've had some wonderful insight from Irshad with regards to how it was the Tax Appeal Tribunal in 1984 and the whole fight, and how now in 2026 finally we see, with the new acting chairperson, we see the advent of this tribunal, the Revenue Tribunal. In one line, I think I wish to say that this was long overdue, and as a practitioner, it is great to see that things have moved. Now, with regards to just to add on what everyone has said, it's interesting because I looked at the parliamentary debates of 1984, and there the then Minister of Finance highlighted that in 1982 there were around 8,000 objections amounting to 97 million rupees in taxes. And in 1983 there were around 9,000 objections amounting to 107 million in taxes. The tax complexity is one thing, but the volume and the amount of tax is now completely different. We've moved into an era where we're not dealing with the same figures. So at the time, that's one of the reasons why the Tax Appeal Tribunal was introduced, to deal with it in an expedited manner. Interestingly, what I found from the parliamentary debates was that I thought the parallel would be one of a trawler going through the oceans and taking the seabed as well with it. It seemed to be more for the amassing of revenue rather than access to justice or the fairness to both the parties. So independence, I think, is one of the main things that the Revenue Tribunal has now established completely. So for me, from a practitioner point of view, as you've asked me, I think it's the tribunal is still in the newborn phase. So it started in January and we're now only in March. A lot of the cases that have started were already before the Assessment Review Committee. So the transitional provision provided by the Revenue Tribunal Act is Section 18. So everything has been taken over by the Revenue Tribunal, but if it's already started, Section 20 of the MRA Act would still apply to the proceedings. And there are new rules that have been established for the new cases. I have yet to appear in a case where the rules of the Revenue Tribunal are going to apply. So I think this will be interesting to see. But I think it's commendable, and it's great to have both chairpersons here, because to a certain extent, the smooth transition has been because despite it being the Assessment Review Committee before, they implemented a certain formality to the proceedings. And that has helped because now from a practitioner perspective, there are certain technicalities that have changed. For example, the witness will come and take an oath, which was not the case before, or the tribunal is called before. These are cosmetics, but mainly the formality that they tried to maintain, both in Irshad's time as chairperson and Mr. Durai Gulshan's time now, has helped, has aided this transition. So that is kudos to them for having done that. Because even in 2024, we had the judgment of Modiello, where the judge took judicial notice and said, well, the Assessment Review Committee was meant to be less formal than a tribunal. But of course, with the complexity of tax matters and how serious tax matters can be, I think it was important that we had chairpersons that took it that seriously, and this has aided the smooth transition. I think another change I wanted to comment on is with regards to the Ministry of Finance. In fact, to piggyback on what you said, Irshad, there was the case of Vaitilingam Daivadasen versus the Commissioner of VAT. This was in 2006, I believe, where the issue was taken that the association of the ARC to the Ministry of Finance created this perception of bias. And in that judgment, the Supreme Court found, well, because there's that right of appeal, and it met the test that you described, it met the constitutionality test, they decided that it was fine. However, I think this always created a discomfort. I have heard this myself from people in the industry. This always created this sort of discomfort from the taxpayer lens, from the investor lens. And now that it's become an administrative tribunal, it's no longer within the Ministry of Finance. It is now under the Prime Minister's office, as are all the other tribunals that have been created over so many years. We have the Environment Tribunal, we have the Public Bodies Appeal Tribunal. But having said that, that is only for the budgeting. The administrative control remains with the chairperson. He is the one who administers the tribunal. So this is important, and even Section 18A of the MRA Act spoke about key performance indicators, and these were placed by the Ministry of Finance on the Assessment Review Committee. Again, this gave a perception of, well, the Ministry of Finance is there to kind of see how many, of course it was there for efficiency and the quick disposal of cases, but it can give this perception of they're waiting to see how many taxes are collected. So I think that being removed is a great step as well. So this has been completely removed from the law. Ryan also emphasized the procedural aspects of the Revenue Tribunal Act. So we have a preliminary hearing within 120 days. There's the 90-day delay post a hearing within which the tribunal has to give its decision. Before, the MRA Act spoke about the ARC endeavoring to give a decision. So now there's an actual time limit to that. Of course, that means probably more work for the tribunal. It's probably more challenging, I think, because the resources have remained mostly the same. So there was that. I also wanted to touch upon the case-stated system, appeal system. So the case-stated appeal system was mainly this system where a question of law is referred to the Supreme Court. I think both chairpersons have seen issues with the case-stated system, where the case-stated had to be drafted by the chair or the vice chair who delivered the decision. The issue with the case-stated system was that it was limited to, of course, issues of law. So it had to be a question of law. Of course, the facts had to be perverse. So now we've made it a full-fledged appeal, which in a sense is a good thing, because tax is oftentimes a mixture of the facts and the law. It's not always only a question of law. So I think making it a full-fledged appeal is a good step. I'm waiting to see how this will come about now before the Supreme Court, because I think the perversities test with regards to facts would still stand. I think it is true that the Revenue Tribunal has the advantage of having members, specialized members, that the Supreme Court does not have. So before displacing a fact, I think it would require a higher threshold. But we wait and see how that pans out. And I think, as a concluding note, taking into account what everyone has said, I think, within the fiscal framework, what this act has done is it's embedded the rule of law, access to justice principles. More importantly, I think it's an ecosystem. And the Revenue Tribunal, in my opinion, is the central nervous system. So there are different actors. We have the management companies, we have the accountants, we have the law practitioners, and we have the chairpersons, the vice chairpersons, but it remains the central nervous system. Yeah. And this act will do a lot for investor confidence in Mauritius as an IFC. And I think this is very important to all of us at the end of the day. This is important even for Mauritius. Mm-hmm. So I view it like that. And I think perception, sometimes perception is as important as an outcome. Yeah. So as cliche as it sounds, justice done is as good as justice seen to be done. Mm-hmm. So yes, I will end with that.
Very sharp analysis, and
Thank you.
You're spot on the fact that perceived independence and from the part of investors and taxpayers altogether is extremely important for the system to be well oiled and to go in a direction that it should.
Yes, exactly.
Very, that was spot on. Now I'll get to you, Gulshan, and since you're here, we're going to pick your brains on a very practical matter. We have had some of our practitioners who would like to have a clarification. Under the previous regime, there was the pro forma, where the taxpayer was setting out all the documentation and the checks were made on the procedural matter aspect for both parties. Now, under the Revenue Tribunal procedures, after filing all the documentation, we arrive at the preliminary hearing. So, can you clarify whether this preliminary hearing is similar to the pro forma step, or is it something different? Or are you going to hear the case as the hearing is set?
Well, the simple answer is it's different.
Yes.
So it's not the same. Indeed, we'll move from PF sessions to PH sessions now. So most often, in fact, why we moved into that direction, most often the pro forma sessions were being convened merely to record a filing, or worse, sometimes just to inform a party that a statutory filing is required in the next 3 weeks. Eliminating these routine pre-hearing pro forma sessions forms an integral part of the tribunal's streamlining exercise. Under the former practice, the ARC, and still now, since as Angie mentioned, we are still dealing with cases which have started under the previous regime, the ARC was convening a crowd for these procedural matters. So at the outset, the number of preliminary hearings in any given sitting will be substantially reduced. Maybe from around 35 on average, as it is now, to 5 or 10, so as to have sufficient time to give to each case. The aim of the Revenue Tribunal rules, which we came up with in 2026, is to have all the filings done at the registry of the tribunal with a preliminary check being carried at the counter to ensure procedural compliance. In due course, we expect that the electronic filing can be extended to these documents, just as the notice of appeal presently. I must emphasize that for the ordinary taxpayer, the regular taxpayer, the only mandatory filing will be his notice of appeal. It is only in cases specified in the RT rules, the Revenue Tribunal rules, that the appellant will additionally require a statement of case, as Ryan mentioned, and witness statements. Rule 3.2 of those rules, in fact, reproduces all the categories where the statement of case was already required under the previous act. So this rule is a mere reproduction of what we already had in the MRA Act. The novelty lies in Rule 3.3, which introduces an additional carve-out. No SOC, no statement of case, will be required where the appellant is an individual who is not in business or an enterprise whose declared gross income is below 10 million rupees for the relevant year. The underlying objective is to improve efficiency and accessibility by limiting the onerous filing obligations for the so-called sophisticated taxpayers in relation to complex issues, while ensuring that the ordinary appellants, as I'm terming them, are not burdened with disproportionate procedural demands. Now, following the required filings at the registry, will come to the preliminary hearing. The law provides that it should be called for a preliminary hearing within 120 days. And in fact, will attempt to have it much earlier in cases where only the MRA or the Registrar General is to file an SOC, which will be the case in several matters. So, the PH session will not replicate the PF session. Obviously, when the case is called for the preliminary hearing, the tribunal will formally ascertain whether all the procedural requirements have been fulfilled. However, since all the filings would have been done, especially where both parties have filed their statement of case and statement of reply, followed by the witness statements, which is in itself an innovation, each party will be called upon to take a stand as to whether it intends to proceed with its case. With all the pleadings, the tribunal will be equipped to issue targeted directions and adopt a deeper case management designed to narrow down issues and promote efficient adjudication. Ultimately, the advanced filings will strengthen the tribunal's capacity to make use of the nuclear power, if I may say so, in these gloomy war times. The power under Section 10(4) of the Act to dismiss an appeal which is frivolous or vexatious without a full hearing. Obviously, this is not a power which will be invoked lightly, just as nuclear power is not invoked lightly. However, its considered and judicious use will assist in preserving the integrity of the appellate process. Hence, to sum up, the PH session will go a long way in attaining the tribunal's mission to resolve revenue disputes in an effective, proportionate, and expeditious manner.
Well, that gives us a lot to chew on, but I think what we take away from this is the welcome shift from PH from PF to PH.
Indeed.
And it's going to be revolutionary in terms of streamlining and getting the cases more efficiently dealt with.
That's the objective.
Thank you.
Thank you.
Ryan, I think we were more than happy as tax practitioners when we're hearing those kind of innovations and changes towards efficiency and less burden on taxpayers. May I ask you for some free advice for our viewers? What should clients, what should businesses be doing in terms of documentation, and what should they be doing to ensure that they are ready, not just when the assessment is done, but prior to that, getting their things sorted?
In fact, I would say, Tanvisha, whenever they are doing a transaction, whenever they are doing their bookkeeping, their record keeping, they should ensure that they keep documentation, because that's what the tribunal will look at. It was already what the committee was looking at, but now even more with the tribunal, because it would be sometimes more written evidence. So in many cases, we have clients who are involved in some businesses, but they don't know, they are paying their salaries, wages, cash. They are using them. They have a company, but they are using money from their personal bank account. They don't have records. They are receiving money from Jews. They are paying money through Jews. They don't have any record. And then one day there will be an audit by the MRA. They won't have anything. The MRA will just look at all their receipts. They can't justify. Sometimes they may have received gifts from their friends, or it can be money they have obtained from their kids, etc., or kids have received money from their parents, but they cannot prove anything. So the MRA will issue the assessment, and if you can't prove it's income, it's not an income, the MRA, they will be right to issue the assessment. And what will you be able to do before the tribunal if you don't have anything?
Yeah.
Yeah. So you need to prepare. You're doing a business. You need to have your proper accounting records. You need to have proper documentation. Documentation can be soft or printed. And whenever there's a query, you can reply. If you don't have evidence, whatever you are saying is not enough.
Cannot be supported.
Of course, there are some cases. I had just seen a recent decision, I think this week itself, where the tribunal has relied on the demeanor of a witness to ascertain that there has been expenses that has been incurred, but it will not be always the case.
Yeah.
So you should have you should have your documentary evidence. The MRA, their job is to get money. The government needs money in any case. So if you can't prove what is the source of the funds, but they can make a reasonable assumption.
Yeah. Yeah, that's true. Whatever the framework, documentation is always king.
Yeah.
And it can always serve you right if you have all your documentation in place, if there are any investigation and assessment. And it helps us as well.
Yeah,
to have
exactly.
The case.
Yeah.
Without any documentation, there's just like a parole.
Yeah. You can have the best lawyer, the best tax advisor, but if you don't have anything, I don't think this will serve you.
Exactly. And there's one thing that was being mentioned in terms of efficiency, the witness statement that is now being submitted as part of the procedures before the preliminary hearing. How welcome is this new step?
In fact, before, each time the committee had to call a witness, the taxpayer. I don't know if maybe Mr. Jurai can confirm afterward if it applies to the MRA as well. But the witness had to depone on his case, everything, or his tax advisor. Now everything is written. Everything is written. So, but what is important is that before, you know that you have lodged an appeal, you have received an assessment, the MOA did not uphold your objection, you raise an appeal, so you say the case will be heard in maybe 1 year or how many time. So you don't need to prepare for the case. We'll wait for, and a few days before the hearing, then you will say, okay, now we need to prepare for the case. But now, as soon as you lodge your notices of appeal, you already need to gather all your evidence.
Yeah.
And it's a good thing as well, because if you are going to prepare it in 1 year,
it's probably going to be lost.
Yeah. And now it's a continuous process. You prepare your statement of case. As soon as you have finished with the notice of appeal, then the MOA will reply. Then you will have your witness statement. So your case is ready. It's a continuous process, not a few days or a few weeks before the hearing. Maybe one thing that maybe some Major I can clarify afterward, if it's in most cases the burden of proof is on the taxpayer, which makes sense that they are the one who prepares the statement of case. But in one specific case, like provided in the Act, is under Section 90, the onus is on the MOA. Does it mean that for Section 90 case, it's the MOA which starts with the statement of case? Maybe we can have a feedback from Major I afterwards.
Do you want to take this or?
Well, in terms of the witness statements, there are two innovations from the previous setup that we had, where we had provision for a witness statement under the MRA Act. And both of these innovations, in fact, I may share, based on representations that we received. So first thing is that the witness statement does not accompany the statement of case. The appellant files his statement of case, the MRA files its statement of reply, and then both parties would file their witness statements. So it would be a witness statement based on the both statements which would have already been, so where each party has already disclosed, so to say, its case. And the second innovation is that this witness statement will constitute the examination in chief. In fact, under the previous regime, we would have sometimes lengthy witness statements, but when the witness steps into the witness box, it would be as if there has been nothing and he would start anew.
Yeah.
So we would have 2 or 3 sessions hearing a witness who has already given his version in writing. So now, at least we would have that witness statement already there, and we would go to the crux of the matter with the cross-examination. So that would be... Well, this is in relation to the burden, I must confess that it is not something that is provided for in the Revenue Tribunal rules. There is a set order. So maybe practice would dictate as to how things would evolve in terms of the issue of burden. I recall the Attorney General, when he was introducing the bill during the second reading of the Revenue Tribunal bill, stated that this issue of burden itself was something that was already there in practice. It was practice which made it this way, that the MRA started without anything in the legislation. So I think maybe practice will also pave the way as to how the order in which the statement of case and the statement of reply would be filed in those specific cases.
Yeah. Sometimes we are bound to just wait and watch how the matters progress, so that we know where to readjust if need be.
Exactly.
In practice, it might not work as intended when the law has been implemented.
Indeed.
Yeah.
Can I just
Yes, of course.
one thing? The reason why the taxpayer normally bears the burden of proof, like Ryan has said, is that it is presumed that the taxpayer is the one who knows his tax affairs,
Yes.
right? So this is why he bears the burden. He's appealing. He has to make a statement of case first. But in the case of tax avoidance or tax fraud, it is the MRA that is averring avoidance of fraud. This is why in these two cases, for fraud, it has always been the MRA that had the burden. For tax avoidance, like my friend Jorai has said, through practice, the MRA started the case, the MRA had to prove. But it's true, they are averring that there is an avoidance, so they know why they are saying there is an avoidance, so they have to start the case. With regard to statement of case, I believe since an averment of avoidance or an averment of fraud is not something that comes up at the end, it's something that's there from the very beginning.
Yeah.
In my view, most probably it will be the MRA that would have to actually file a statement of case, explain why they think there is avoidance or fraud. Then the taxpayer will have the opportunity to actually reply and explain his case. But this is my view. We will see, like Mr. Jorai said, the proof of the pudding is in the eating. We'll see how it goes.
Certainly, certainly.
I'm also glad to hear Angie say that the tribunal is under the Prime Minister's office now. It so happens that the Prime Minister is also the Minister of Finance, so on n'est pas sorti de l'auberge.
Yeah, that's definitely true.
But it is only administratively, as
Exactly.
she added, so for budget purposes. And it's the same for all the tribunals. So that has been a setup which has worked. I don't think the Employment Tribunal or the Environment Tribunal have had issues with that.
Yes.
So it would be the same setup.
In one last thing, Ryan has said that regarding documentation,
Yes.
as a barrister, practicing barrister, I also
Yeah.
come across this problem. You see, the people who are not accountants, who are not lawyers, people who are what we in our jargon call laymen, when they are doing their dealings, they don't think, what is the MRA going to say about this?
Yeah.
He takes money from his bank account, he puts it in a small company that he has, and he takes money from the company and he does his things. He doesn't ask himself, how is the MI going to treat this? You see? But I think personally, it's true that if you don't have documentation, you cannot prove your case, it's a big problem. But I think that the people who are sitting at the tribunal, Mr. Joy and his assistants, I think they are quite experienced lawyers, and they will be able to, on a case-to-case basis, decide whether somebody genuinely did some dealings without documentation because he did not know,
Yeah.
or he's trying to fool around. Right? But obviously, with the witness statements, it will not be possible now to, how do you say that, consider the demeanor of the witness to decide a case. That will not be possible anymore.
I think we've chatted it.
Can
Of
I
course,
come
of
in?
course. Go ahead.
Just to add on what everyone said, I think with burden of proof, we have it in Section 9, and this was always being done. This was being done by practice. It's now being codified. We as lawyers, we know that there's the principle of he who avers must prove. So this is exactly what it is. The taxpayer is averring that the assessment raised and the notice of determination is erroneous. For these reasons, this becomes their grounds of appeal, past known as the grounds of representations. This is why they hold the burden of proof. And Section 9 has helpfully also carved out the exception with regards to Section 90 and Section 37. Now, for the sequence of statement of case and statement of reply, I think it can stay the same. It is just that as it was being done previously, the MRA would then start the case. It would be similar to a plaintiff and a defendant, but then if the burden shifts, the defendant would still need to prove what they are also averring in their plea, or in this case, in their statement of reply. So yes, of course, the burden shifts with regards to Section 90, but practically speaking, the shift would occur during the hearing. I think the procedure of statement of case and then statement of reply and then witness statements can remain the same. I think it's excellent that we've introduced witness statements, even for practitioners, because I've had experiences where there are no witness statements, and we have witnesses who can go on from 10 a.m. to 4 p.m. in the office. I've had that before, Gulshani himself. And sometimes we don't know what to expect. And what happens with that as a practitioner is you're bound to wait for the copy of proceedings, and then, of course, the hearing takes more time than it should. So I think witness statements are going to go a long way for efficiency and creating this form of speedier justice. And I also wanted to comment on, there was a sticky point that has been raised again and again. It was with regards to documents that have not been produced at determination stage, and appellants or taxpayers then try to adduce them during hearings. So Section 9 has brought a clarification to that. It says, well, you will not be allowed unless there's reasonable cause shown. Of course, reasonable cause will probably be argued. There probably will be rulings on what amounts to a reasonable cause, but at least we have a section that now looks after that. It was a gray area, because we had rulings where they were not allowed, and then we had rulings where, in the interest of justice, these documents were allowed. So it's opposite ends, both, I think, both defendable in their own way, but I think the law bringing that clarity is also a good thing. So this is what I wanted to add.
That's interesting, and we have been seeing that there are provisions for mediation under both the previous Act and the Revenue Tribunal Act. What would you highlight as the main difference in the new framework? And do you, in your experience, see mediation as a recourse that is sufficiently covered or even considered by both parties?
I think with regards to this question, Tanuja, I want to use the quote that is often associated to Winston Churchill. We were just talking about him before the panel. He said, "More George or less war," and this is actually apt in the current scenario we're seeing in the world. I think mediation is an important feature. I think it is highly suitable to tax disputes. And I say this, one of the main reasons why I say this is, as I explained, it's an ecosystem. It's the same people in this ecosystem. It's a small world. At the end of the day, we all know each other. A taxpayer is probably going to have to deal with the revenue authority again and again. Mm-hmm. It's not one dispute and then matters end there. It's a relationship that goes on. Even for counsel, so you know opposing counsel, you get to know those appearing before the tribunal. So to me, within that ecosystem, I think mediation is a right format that ought to be used and that can be used. I have to admit that under the MRA Act, so it came about in 2022, I believe. I never actually used it. But I think it was restrictive in the sense that it was during a hearing. It was brought about by the chairperson or the vice chairperson, so not necessarily the parties. Yeah. It was limited to one meeting only. I think a complex tax dispute has the characteristics for mediation, and I don't think a complex tax dispute can be sorted out within one meeting. Mm-mm. Oftentimes we see with tax disputes there are issues of facts, there are issues of figures, and there are issues of law. The issues of figures are probably more easily solvable around a mediation panel rather than always the sort of adjudication that we see. Having said that, so I think the mediation that has been introduced in the Revenue Tribunal Act is wider. I think it gives a real chance to dispute settlement. It's not one meeting. It is also the parties that have to write to the chairperson to state that we are willing to mediate, which is a good thing, because if the parties themselves are willing to come to a table, that's already half the battle won in a sense. Yeah. Another major difference is that the panel will be there. It will not be the chairperson or vice chairperson alone. It will be the panel. Something I think very innovative is also that the mediation can also be used as a technique of case management. And I thought that was very interesting and very smart, because mediation can also narrow down issues. And in fact, if mediation is used, they remain without prejudice unless the parties waive it. So they remain confidential. You can remove it from the record after unless parties wish to waive it. But you can also choose to narrow down your issues. So maybe you've not sorted out the entire dispute, but you've narrowed down your issues. So now when the matter is referred back to the vice chair or the chairperson, they will draw up a memorandum of the disputed issues. And this will become the guiding path for taxpayer and for the authority. And I think that is a very good use, a very efficient use of mediation as well.
Certainly.
So all in all, it is a welcome move. Mm-hmm. I think it will be good to see how it pans out in practice. Yeah. I hope that we will use more mediation now that it is not limited to one meeting only. And I hope this will bring more efficiency to the tribunal as well.
Yeah. All right. Ryan, building on what Angie is saying on the mediation, how has been your experience with mediation? Is this something that is being considered by clients? Is this something, because now, as she mentioned, the framework has changed. It has extended a bit the ambit and the possibility of reaching out for an alternative recourse. What are your views on that?
I think during the recent years, I was not really a big fan of mediation, because without the presence of someone from the committee. I think some time back there were committee members. I think when the ARC was at the La Bourdonnais Street, we often had several informal meetings there. There was a member of the committee which was always present during the informal meeting. But in recent years, an informal meeting was only between the taxpayer and the MRA. And then the councils as well were not there in most cases. And what we have seen that in this situation, sometimes, it can be sometimes the taxpayer or sometimes the MRA, that the mediation is used just as a delaying tactics. You're not ready for the case, okay, we'll go for informal meeting, then we have not come to an agreement. So now, with the presence of chair, vice chair, or the members of the tribunal, both parties won't be able to act in bad faith.
Yeah.
They would need to show real.
Substance.
Yeah. And this, I think, will really help with the case management. Because sometimes there are a lot of issues, but many of the issues are not disputed. We have often in various cases, we see either the taxpayer or the MRA come and state a lot of facts, but these facts have never been stated, and these are already in the statement of case. So which the tribunal is not required to give a decision on this. So the mediation will really try to, even if it will not be able to resolve the case, at least narrow down the issues.
Yeah.
And just regarding mediation, I think many taxpayers also don't know that in case there are already mediation that sometimes are carried out in dispute resolution at the state level, where the tax authorities need to negotiate. For example, in the case of the treaty between Mauritius and South Africa, where there is, if the MRA is saying that the company is resident in Mauritius and South Africa also is saying that the company is resident there.
Yeah.
So the treaty provides that it's both authorities that will need to come to an agreement.
Yeah.
And there is also the mutual agreement procedure under the all tax treaties, which is a separate mechanism from the appeal mechanism from the tribunal. And in some cases, taxpayers can choose to use the mutual agreement procedures when it is provided, because it's not in all cases. It must be in cases where there has been breach of treaty.
Yeah.
And then if mutual agreement procedures, the taxpayer will bring the case to the authority where he's a resident.
Yeah.
Then the authority will see if he is agreeable. If he's not agreeable, then he will negotiate. He will contact the other tax authority, who will negotiate. If they come to an agreement, it's okay. If they don't come to an agreement, then it can even go to arbitration. Yeah. And this can help in some cases.
Yeah. And this is why you need to have an experienced practitioner who can guide you through the different recourse and not just going through just the normal route, because alternatives are available and we need to explore whether these make more sense than just going for appeals in front of the tribunal.
Yeah. Just before we move on, I would like to add something. Is that it's true that like Angie said, that now it's formalized in only specific cases that you can bring new evidence, and it's like in a court of law. But I'm not sure, the law doesn't say it, but I understand that that's how it will be applied by the tribunal, that this doesn't apply only to the taxpayer, but it also applies to the MRA as well. Yeah, and the other things that I would like to highlight is that, unfortunately, but this is the law has already been enacted, And this could have helped taxpayers and even the MRA who are engaged in litigation. You know, sometimes now the process is that you have an assessment, you have to appeal to the assessment to the MRA, and the objection unit of the MRA, then you appeal to the tribunal.
Yes.
This is good, but there are some cases that we already know when there is an assessment that the MRA will maintain the case because there are already several disputes which are already at the level of the tribunal, and it's regarding really the interpretation of the law that the MRA will not be able to resolve it.
Yeah.
So maybe there could have been a carve-out that in some specific cases, this appeal could have gone directly to
The tribunal.
the tribunal, because now we know that it's only an administrative process that we need to appeal to the objection unit. They will need to ask queries, they will need to issue a determination that we know what will be the...
And it just drags on the case.
It just drag on the case, and I know that the objection unit of the MOA has to look at a lot of cases. Sometimes they don't have the time to look deeply at all cases. This would have helped them as well to concentrate only on cases where they can intervene.
And that can be an outcome of it, right?
Yeah.
Definitely, that's a good point to make. Irshad.
I would like to say
Yes,
something
I
about...
think I've seen you
Ryan has mentioned informal meetings.
Yes.
I must say, informal meetings were not mediation.
Yes.
Not even close. Informal meetings wasn't provided for in law. It is a very ingenious system put in place, I will not say by the MRA, but it was by the MRA, to actually have beautiful statistics. I'll explain. At first, the objection unit, objection, appeal, dispute, whatever, OEDR, had 6 months to determine an objection.
Yes.
This was reduced to 4 months. I mean, let's be honest. These officers of the MRA at the OEDR, very often 4 months was not enough for them to actually determine an objection, to consider all documents and all that. So what they did, as Ryan said, maintain the assessment, tell the taxpayer, go to the ARC at the time at the ARC. Then when they come before the ARC, let's have informal meetings. That's when they actually consider documents and review their assessment, right? But statistically, the case is not before the MRA. The case is before the ARC.
Already.
So we get all the blame. You're taking too long. You're not disposing of cases as fast as we would have wished. And look at the MRA. They are so fast, so efficient.
They already found a solution.
Yeah. So everything was on our back. We had very large shoulders, you see. But now, with this new system of the tribunal, I hope this game will not be played anymore. Each one takes his own responsibility.
Yeah.
But let's be honest, 4 months to determine an objection is not reasonable in all cases. For instance, if you get a big transfer pricing cases,
It's tough.
I'm not sure they can do that.
And also there's the question of resource management. The resources available both on the side of the MRA and of the ARC. I think this is a challenge that we've seen, that we have so many cases and they have to juggle with so many cases, but the resources are limited. Irshad, thank you for that point that you made. We are reaching to the end of the webinar.
Thank you very much.
One last thought from your side on the future of the tax dispute process, and probably if you would have something to recommend to...
Well, I think this new law, the Revenue Tribunal Act, is actually going in the right direction. This is what it should have been all this time when we had the ARC. Obviously, there will be some fine-tuning to be done. Like my teachers used to say, room for improvement. but it is going in the right direction. And as we go along, I am sure we will find what's not working properly. And but I am especially betting on the experience of the chairperson and the vice chairpersons and the members
Yes.
to, just not apply rules indistinctly to all cases, and to go on a case-to-case basis and decide cases as they should be, taking into account the person of the taxpayer, his intelligence, his education, all that matters,
Of course.
right? So when you're dealing with a big multinational and when you're dealing with somebody who is a vegetable seller,
Yeah.
it's not the same game, right? But I think, I'm sure the tribunal will be able to function properly from now on.
I think that's huge responsibilities on your shoulders coming from Irshad, and would love to have your final thoughts on this matter.
Well, indeed, there is a lot sur la planche.
Yes.
Well, at the end of the day, the future of the tribunal will be the product of institutional discipline and the collective commitment of all stakeholders. The Act and the rules merely provide a framework, a very forward-looking one, I may add, but it will be for us all to ensure that this framework is not clogged with superfluous procedural formalities which deviate from focusing on real issues in controversy. Fair taxation implies fair adjudication, and the tribunal is determined to live up to these expectations. To conclude, I wish to express my sincere appreciation to the Finance and Tax Academy for convening this webinar. Initiatives of this nature contribute meaningfully to stakeholder awareness and professional engagement. I'm confident that today's deliberations will materially assist practitioners, taxpayers, and the administration alike, and will complement the Revenue Tribunal's own initiatives in the sensitization efforts in support of this pivotal institutional transition. So I make it a point to thank you for this webinar.
But thank you to you, Gulshan. Thank you, Angie. Thank you, Irshad,
you very much.
and Ryan. And absolutely, as you're saying, that the purpose of this the webinar is to have a platform where exchanges or happen, where we are able to breathe in the changes and probably have thought-provoking ideas on how we want the future to be paved. And it should not in any case be viewed as a debate or a face-off of any kind. We are hopeful that other institutions will join us in other initiatives, namely the MRA as well. I think it would have been great to have someone to present at the MRA. We have spoken at length about the challenges we face, and I'm sure that they also have the voice to share what are their challenges on their end. But thank you so much, panelists, for being there, for attending. Ladies and gentlemen, as we come to the end of today's session, I would like to extend my sincere thanks to all of you for joining us and for your active engagement online. I've already said it, words of appreciation and thanks for my panelists. I think the discussion was very friendly, very conclusive about how, in what a good direction we're going through with this reform. And today's webinar has given us a clearer understanding of the long journey from the early days of the Tax Appeal Tribunal through the ARC and now into the new era of the Revenue Tribunal. For practitioners, taxpayers, institutions alike, this is a moment of transition, right, that calls for adaptability, clarity, and collaboration. And today's dialogue has shown that all stakeholders are committed to ensuring that this system evolves in a way that is fair, efficient, and transparent. On behalf of the Tax Academy, thank you again for being with us. We hope today's exchanges have been valuable to you, audience, and we look forward to continuing the conversation through future sessions and initiatives. Thank you for joining us this afternoon, and as we conclude, may the clarity gained today stand firm without grounds of appeal.
Thank you. Thank you.
Thank you.
Thank you.
Thank you.